Hello, everyone, and thank you for joining this Use Laboris webinar on supply chain safety. My name is Alessia Perez, and I will be facilitating the session for you today. Today's webinar will be given by a set of panelists, all from different member firms. Today we have lawyers from Belgium, Brazil, Italy, Mexico, and Spain. Before we kick off the session, I will clarify a couple of points on the housekeeping side. If you have any questions throughout the session, you can use the Q&A tab to send your questions to us, and the panelists will answer as many as they can in the dedicated Q&A session at the end. You can, of course, also reach out to the panelists by email after the webinar. Regarding the slides, will be available on our website along with the recording after the webinar. That's all for me. I will now turn over to Stefano from Toffoletto De Luca Tamayo to begin the session. Go ahead, Stefano, you're welcome to start.
Hi, Alessia. Thank you very much for the kind introduction, and thanks to the audience for joining this webinar. I will just say a couple of words before introducing our panelists. In today's productive organization, outsourcing and subcontracting are getting more and more common. When the service contract is performed within the principal's premises, employees of different companies may end up working one close to the other in connected activities. This creates important challenges in terms of health and safety management. We will be discussing this topic with our panelists, which are Kenny de Cruiner from Belgium, Bruno Perez from Brazil, José Miguel Mestre Vázquez from Spain, and Gabriela Guadarrama from Mexico. So welcome again, all of you. For example, for these cases I mentioned before, in Italy, Italian law sets several obligations on the principal, such as to verify the technical and professional suitability of the contractors, to provide the contractor with information on the risks related to the principal's activities and on the prevention measures adopted to reduce them. And moreover, the principal must cooperate with the contractor in the implementation of measures to reduce risks due to interference between different activities. So my first question to the panelists is, what are the main obligations that companies face when managing health and safety across the supply chain? And Gabriela, if it's okay, I will start from you, so from Mexico.
Great, sounds perfect. So thank you everyone for being here. Well, this question is really important to clearly understand the context of the obligations in health and safety. So for example, in Mexico, what happens is that you, as an employer, have the obligation to have a health and safety joint commission that must have equal representation from employer and the employees. So this commission, what it does is basically they conduct quarterly inspections at the workplace. They investigate any occupational hazards or any occupational incidents. And they also recommend preventive measures from time to time of what to do if maybe there is an electric connection that it's not well and that may represent a risk for employees. Then they keep all these records, they document those observations, those recommendations, and they take pictures, and then they follow up in the next quarterly inspection. So also the legislation provides that online platforms must exist to help companies access the regulations on health and safety, develop their own safety programs, and evaluate compliance. So these online platforms also help this joint commission to make their job and have these actions to prevent any occupational hazards. Additionally, all employees must receive training on the minimum health and safety measures for performing their duties, and this is mostly common in the industry when you have manufacturers or the chemical sector, that you must give them some training for them to provide their services in a safety manner. Also, this is a key legal obligation, and most companies that have an internal work regulation that is basically also sort of an employee handbook in other countries. So these internal work regulations must also contain training in safety and health policies or measures. So you as an employer should set minimum training things in the internal work regulations so that you can follow up with that. That is also an obligation. And also the cleaning and first aid instructions for employees and disciplinary measures that are also important if employees do not comply with your regulations. Also, it is important to mention that in this context, internal work regulations do not directly apply to contractors or third-party employees that may be present in the workplace. But although they are not mandatory, many companies establish occupational health and safety policies to protect the well-being of their employees in the workplace. And when contracting third parties, it is common to share these internal safety policies with the contractor's employees or the independent contractors so that they are aware of the rules that they must follow when they are in the workplace. However, due to these outsourcing regulations that I think we're going to talk more about this, but if you are a little bit familiar with Mexico, there was an outsourcing reform that established that you cannot outsource other services, but only those that are specialized and not related to your core activities. So in those specific cases, even though the hiring company may not say to the employees, okay, this is what you must follow regarding safety and hate and health rules in the workplace, what usually happens is that communication goes through the contractor so that instructions come directly from the contractor to its own employees, and they must follow those health and safety rules. However, there are additionally some mandatory standards in Mexico known as Mexican official norms, which establish also occupational health and safety requirements. And most of these regulations address specific rules to high-risk industry, such as the mining and chemical sectors. So actually, what happens with health and safety legal obligations is that most of them can vary depending on the industry you're in as an employer. So that is from the Mexico side.
Thank you very much, Gabriela. It was very interesting. Jose, anything to say from Spain?
Yes, of course. First of all, thank you for inviting me in this webinar, and let's see the angle from Spain. Well, we have two. We know we have two main international rules. We have the ILO Convention of 155 of concerning occupational safety and health and working environment, and the Council, which dates back to 1989. And I think it's going to be renewed. That's an evolving issue in Spain because it was transposed internally in Spain by means of our Law 31 1995, which makes 30 years now, about occupational risk prevention at the workplace. What does this internal rule say? So what are the obligations? No, it's answering your question. Well, when we have multiple companies, contractors, subcontractors operating at the premises of one single entity, obviously there is obligation of coordination. Okay, and this coordination obligation means that they need to cooperate. How they have to cooperate? Obviously, they need to apply preventive measures. What are those preventive measures? First, they need to know what each one the activity is, what are the boundaries, what is the specific activity at the workplace they are doing, so they are separated. Look out with this, because an activity that is not correctly, appropriately separated will lead to maybe not only maybe sanctions respect to infringements to health and safety issues, but also will entail consequences, legally speaking, as a confusion between employees of one entity to the other. So that's very important for the principal to establish clear difference, physically, activity, etc., with the employees. So one is the coordinated measures in terms of safety risk prevention. The principal need to know, the main company needs to know what the activity is going to be carried out at the premises and what are their risk assessment. So at the beginning, it is very important, that leads to the second obligation, the risk assessment and the planning. Each company must carry out a risk assessment, or let's say an evaluation of each working position, because obviously it is not the same kind of job if you go up in a head, or if you do electricity or electrical works, for instance. And related to this, a preventive plan, measures related to this preventive plan that they need to be carried out by each, I repeat, to each company. This information has to be reciprocally, mutually shared. So they need to know what is the activity of each one. Obviously, each company needs to inform and train, as my colleague from Mexico has explained, to their respective employees. They need to be trained in order to render services under guaranteed appropriate measures, so as to avoid risks in terms of accidents. Then, unlike the Mexican example, there is not a joint commission, but it is mandatory under the internal law, Article 24, that we have coordinated activity. What means coordinated activity? There is obviously a preventive risk specialist person designated by each one, the contractor, subcontractor, or the main company, that will be appointed as coordinated, and they need to write and act about, any issue related to HS. So at the beginning, and also the supervision, the coordination of activities along the way, along the activity goes on. And finally, obviously, there is an obligation of documentation with regards to records of risk assessment, safety plans, coordination reports, and training. Also, monitoring is expected. So this is more or less what I have to say about the Spanish law.
Thank you very much. Thank you very much, Jose. Now, moving back to Latin America, Bruno, do you have any comments from Brazil's perspective?
Yes, I do, Stefano. Thank you very much for that. And thank you also to all the attendees for being here with us today. Well, first of all, I would begin by saying that in Brazil, the contracting party must be sure that the services provider, that is the company that was hired to provide the services, is complying with the health and safety standards regarding their employees. Because the contracting party may be held accountable, responsible for anything that happens to one of the outsourced workers, depending on the circumstances. So even when these workers are not working inside the contracting party's premises, the contracting party must be sure that those workers that are working elsewhere, maybe in the services providers premises, they must be sure that they are having the appropriate safety and health measures being complied with by their employer. But more specifically, the Brazilian labor law provides that when the work is performed at the contracting party's premises, the contracting party, so the company that is outsourcing a part of its activities, must take other steps, additional steps, to make sure that all these workers will be taken care of. So this contracting party must, in this case, first provide training to the workers when the activity requires such training. So depending on the activity, some kind of training may be required by the rules set forth by our Ministry of Labor and Employment. And in all such cases, the contracting party must by itself provide such training. Second, the contracting party must also provide medical and outpatient care when these workers are working at its premises. And third, the contracting party must provide the same sanitary conditions and occupational health and safety protection as provided to the contracting party's own employees. So whenever all these workers are working at the contracting party's premises, all these measures must be taken by the contracting party itself. And all that in addition to all the other obligations that the services provider must have towards their employees. And besides all that, the contracting party must also be careful and analyze if there is any norma regulamentadora, mandatory standard, as we call it here in Brazil, that is set forth by the Ministry of Labor and Employment. So the company has to take care and see if any mandatory standard applies to the particular services that is being outsourced, because some activities they have a particular mandatory standard applying to it. So the company may have to take additional steps in order to comply with all the safety and health norms in a particular case.
Thank you, Bruno. I see that there are several points in common already, but let's see, Kenny, please tell us how it works in Belgium, and so then we can see exactly what points in common we have across the jurisdictions.
Thank you, Stefano, and thank you everyone also for joining the webinar. I think to answer immediately your question, we have quite some similarities with the other countries in this call. In Belgium, the key legal instrument governing health and safety obligation is the Well-being Act, and normally this legislation, the Well-being Act, normally applies towards the direct employees, but in some cases it also applies towards third parties, towards subcontractors within the supply chain. And this is the case when contractors, subcontractors, or even self-employed persons perform work within a company's premises, within a company's facilities. And the formal condition that should be met in order to make this legislation applicable is very simple. There is some kind of work to be performed by an external party, the contractor or subcontractor. This work is performed within the facility of an employer who employs his own workers within these premises under a contract, or if there is no written contract, with the employer's consent. And these works are performed outside of construction works. We call it in Belgium temporary or mobile construction sites, which have specific requirements and separate rules. Think of the example that a company specialized in all kind of technical works comes into your premises to perform technical works towards production lines, machines, etc. And when we look at the obligations, we need to make a distinction between the obligations of the employer of the premises. I also heard the name of the principal, or we call it as well the facilities employer, on the one side, and the obligation of the contractor or subcontractor on the other side. When we look at the main obligations of the facilities employer, of the principal, first is risk communication and training. Risk communication, the facilities employer must inform contractors, subcontractors about, for example, the specific risks that they will meet when they are within the premises of the employer, within the facility. They also must be informed on the preventive and protective measures that should be followed when facing these risks or when working within the premises. And of course, they also should be informed about the emergency procedures, first aids, fire safety, etc. Second point is that is regarding training of external workers and to give instructions. The facilities employer must also ensure even if they are not his workers, that external workers receive appropriate training and appropriate instructions relevant to the facility's operations. So we talk here about the preventive and protective measures that are in place within the facility. So the employer must inform the contractor, but on the others, in first instance, but in the second instance, he should also ensure that the external workers have received appropriate training on these preventive and protective measures. You can move over to the next slide, Alessia. When we look at the second part of obligations, or for the facilities employer, we also need to look at reception and coordination obligation. Understood from Jose Miguel that coordination is also key in Spain. A tailored reception must be arranged for external workers. So you should know who is in your premises, what are they doing, and you should provide a tailored reception to ensure that they have received all necessary information, as I talked 2 minutes ago. Secondly, employer must also coordinate all interventions to ensure safety and collaboration between all parties. Because when we talk about all parties, we can think of the facilities employer and the subcontractor or the contractor, but also other subcontractors could be on the premises, could be within the facility, and these interventions must be coordinated. We should also provide contractual well-being clauses within our written contract. This is a formal obligation to provide or to foresee written clauses within the contract between the parties, and these clauses must foresee into the requirement of contractors to comply with well-being obligations within the premises. It should also allow the facilities employer, to intervene if contractors fail to meet their obligation. Also, agreements must be made on who will be leading the investigation if a serious work accident occurs within the premises. And we should also ensure, as a facilities employer, that the subcontractors of our contractor are bound by similar clauses. And last but not least, in Belgium, there is an obligation to exclude non-compliant contractors. So contractors who are known to breach well-being regulations must be excluded by the facilities employer. And this can be based on past performance. This can be based on certification, think about VCA, etc., or even failure to meet contract specifications. When we move over to the next slide, when we look at the obligations of the contractors and the subcontractors, we can summarize them as followed. We talked about coordination obligation of the facilities employer. Well, the subcontractors must cooperate with the employer's coordination efforts. They also retain full responsibility for managing risk related to their own activities, and they also have the obligation to inform the facilities employees about the risks they bring into the facility. Let's think of a chemical plant, and the technical firm needs to use fire to perform their work. This should be the information that is shared between both parties. And of course, they must also ensure that their workers comply with the facility-specific safety measures. And when we talk about these obligations, we always think about occupational safety. So it's important to emphasize that in Belgian legislation also foresees or requires that employers address psychosocial risks, such as violence, harassment, when their workers interact with third parties. And looking at these obligations, we think of the obligation to maintain a prevention policy that accounts for third-party risks, to offer psychosocial or psychological support, or to even facilitate internal or external procedures for resolution that should be provided by the facilities employer. So that's in a nutshell what the Belgian obligations are.
Thank you, Kenny, and thank you very much to all panelists for your comments. It's interesting to see from my point of view that although each country has its own specifics, there are indeed some common grounds. We have heard from our speakers that all countries somehow involve the principle in the protection of the contractors employees' health and safety. This is ensured in several ways, such as by imposing the principle, the obligation to verify the technical and professional suitability of contractors, as we have seen for Italy and somehow also for Belgium, or by providing on the parties, so principal and contractor, the obligation to inform each other on the risks connected to the activity of each and to set up common measures to prevent such risks. Again, this happens in Italy, in Belgium, and we have seen in Spain too. Or also by providing some sort of liabilities on the principle for the protection of health and safety of the contractor's employees. So there are indeed some common grounds. Let's now move on to some practical aspects of managing risks when contractors are involved. My next question to the panelists is how do companies typically handle this kind of risk prevention? Could you share any examples, whether good practices, pitfalls, that illustrate how these issues are practically managed by your clients? I would say, Jose Miguel, if it's okay, we can start from Spain.
Yep, of course. Well, the employer must think about this. Let's consider this. Everything that has to be done, let's see, from the legally speaking, all the obligations, duties, they have to be perfectly accommodated. You need to be complying with the law perfect. Why? Because at some point there will be an accident, and then it's going to be maybe fatal or not, but will derive in personal injury. Then the work inspection or the judge, the administration is going to scrutinize if everything was correctly done. Okay. Based on this premise, we need to see, let's put on the paper pair of examples from the Spanish perspective. Also, always when I face, for instance, an inspection, I try to do things correctly done, assessing the entities, the clients, and that is a pair of examples. First, at the beginning, of the hiring or contracting with another entity, with a third entity, there are two essential documents from contractors that need to be fully signed and complete according to the law. First is the risk evaluation or assessment document. It has to be correctly and very concretely done, informing about the hazards and risks that every single work position may entail. That is absolutely mandatory. Secondly, the prevention activity planification document that is based on those risks. These two documents, plus a strict compliance with obligations of info and training of employees working at the same workplace, will give a sense of things are done in a correct manner. Okay, in terms of credibility, in terms of why I'm insisting on this, because one thing is the theory or the documentary proof, and then it has to be brought, it has to be moved to the practical side. An entity could just comply with what the law says in terms of obligations, but then needs to really execute these documents in the place, at the premises. So this documentation before start working is of the maximum important. Okay, then maximum diligence here is required. Then going back to the second point I was announcing before, there should be a clear assignment of responsibility. There is the figure or the coordinator figure of business activity, whose role is to ensure that the different entities coordinate relevant risk info, check that preventive measures are computable, etc. Why I'm insisting so much in this? Because when an accident occurs, the first thing that the inspector, I repeat, the judge will look into will be acts. There are the coordination acts. So here's a second tip or advice for a common good practice is that every single meeting with the coordinators of HS of companies involved, subcontractors, contractors, and the principal need to be put on a piece of paper. Is basic that these measures, in case of detecting errors, mistakes, or needs that need to be adjusted or adopted, put in a paper. Why? Because then it's very complicated. You know that in the premises of the principle, the kind of liability that will entail in this kind of cases will be joint and several. And it's very complicated to demonstrate that there was no responsibility liability in terms of contracting your own activity. That is something that would lead on to a lot of jurisprudence that is not the case, but at least from a, I repeat, formal and material way of doing, I will just be practical on these two elements or examples. Then we have also the monitoring and supervision. There should be constant, obviously, periodic meetings between subcontractors, contractors with audits, checks, double checking that the preventive measures are complied, are respected, and also the training and information. Every single change on the activity of the workplace should be reviewed, and that should be also recommended, documented, sorry. So that is, it includes a duty to be constantly reviewing the documentation, but is the best way to approach this case. Thank you.
Thanks to you, Jose. Bruno, do you have any comments from Brazil?
Sure, I do. Well, first of all, I believe that the contracting party and the contractor must conduct a joint risk assessment at the beginning of the services, just as Jose Miguel said in Spain, just to make sure that both companies understand any and all risks involved in the activities to be performed. So this initial meeting, this initial joint risk assessment may give the companies some light on what are the main topics, the main elements that they have to pay attention to throughout the activities to be performed. And second, I would probably say, well, we always recommend our clients here that the contracting party must require the contractor all certificates proving that the workers had been appropriately trained before the beginning of any actual activity. So following these two first recommendations, the contracting party will be sure that it has analyzed all the risks and made a reasonable assessment together with the contractor, and it has all the evidence that all the workers have the appropriate training to perform the activities that they are going to perform. So I think this is pretty basic. And on top of that, I would probably say that the best practice that I have been recommending, I have been recommending our clients in Brazil is to draft a contractual clause with the contractor, authorizing the contracting party to audit the contractor's compliance with the health and safety standards, all in accordance with the data privacy rules, of course. So such clause will authorize the contracting party to request the contractor documents and information proving that the contractor is complying with the law, especially with the law pertaining to health and safety measures. So by doing that, the contracting party can be sure that all these services are being made with the observation of the law. And also the contracting party may even terminate the contract if the contractor does not comply with these basic rules, thereby relieving the contracting party of any liability related to these services.
Thank you, Bruno. Thank you very much. Kenny, what about Belgium?
Well, in Belgium, unfortunately, definitely not all companies handle the coordination and risk prevention in a compliant manner, which leads to work accidents, to serious work accidents. As a matter of fact, we see a lot of serious work accidents with workers from third parties within the facilities employer premises. typical example of a pitfall is a lack of coordination. I will be more specific with a so-called textbook example of a work accident that occurs due to lack of coordination. Let's say a worker of a subcontractor suffers a work accident, sometimes fatal, whilst he or she is working on or within a machine of the facility's employer. And then if the machine is accidentally started by an ignorant worker of the facility's employer that was not aware that a worker, that a third-party worker or even another worker was working on or within that machine. That's a typical example of a pitfall, lack of coordination. People do not know when other parties are working within their premises, and then these kind of accidents occur. And after such a serious work accident, Health and Safety Inspectorate will always thoroughly investigate whether the parties involved have respected their specific obligations when working together. I, of course, refer to the obligation I explained earlier. I will not repeat myself. And when thinking about good practices of coordination and risk preventions, I'm thinking about, without repeating some good practices that already have been mentioned, I'm thinking about joint risk assessments with all contractors, so between parties before starting specific high risk tasks or projects. At least check whether the subcontractor has indeed performed its risk analysis on the works that will be performed. We also think about mandatory safety certification. I already mentioned VCA, but mandatory certification for all subcontractors could help as a double check if we are indeed working with a party that respects its health and safety obligations. I talked about VCA, but it also could be an internal certification that could be applied. Some of my clients already use some kind of blacklist when they have negative experiences with some subcontractors. And this should also be the case, as it is an obligation in Belgium to exclude unsafe subcontractors. I'm also thinking about mandatory safety induction to be followed by the workers of the subcontractors. That could check the obligations related to reception and information obligations. And most of all, parties should also invest in oversight and coordination. Oversight, even when you have contractual obligations, etc., you should monitor your subcontractor if the subcontractor is respecting its health and safety obligations. Even when you know that you're working with a good party, even when you have contractual clauses, you should maintain monitoring and verify periodical whether the subcontractor is following its obligation. When we're talking about coordination, I'm thinking about coordination meetings, briefings, etc., already mentioned also by the other speakers.
Thank you very much, Kenny, for sharing your experience, your professional experience on those good practices and pitfalls. Gabriela, could you also please give us some insights on what is happening in Mexico?
Yeah, of course. So what happens in Mexico is that when you hire another company to contract some specialized services, is that it creates a joint liability between the parties. So the hiring company and also the contractor are going to have this joint liability from the employment perspective, from a tax perspective, from a social security perspective. So it is really important, as our other panelists have said, to have this reasonable assessment, first of all, when you are hiring a third party to provide services. So you must think about if the employees have the right safety equipment, or if they have enough training, or if they actually know the policies, the health and safety policies of the workplace. So yes, of course, contracts also help a lot in these cases. So when you have a specialized services contract what we usually require contractors is to train their employees on occupational health and safety regulations, to communicate these safety rules to follow in the hiring party's workplace. And if the contractor's employees provide violate any safety standards or pose any risk to other persons in the workplace, that this can justify the contract termination or may justify that the contractor applies some corrective measures or disciplinary measures to their employees. So also, if the workplace lacks proper safety conditions, the hiring company may be held liable unless it proves the employee was at fault. So it is really important, as I said, that and that is why the Joint Commission for Health and Safety in Mexico works really well, is that if there is something that needs to be corrected in the workplace, then we should put attention to that. Because what happens is that if we mismanage these accidents at the workplace, or if it can be proved that the company was the one that didn't do any corrective actions to prevent this kind of occupational incidents, is that it can lead to labor, social security, civil, and even criminal liability, depending on the severity of the case.
Thank you, Gabriel, and thank you everyone for your insights. Again, there are some relevant differences, but also I see some common good practices shared in the different jurisdictions we are analyzing. These include, for example, the achievement of proper documentation in advance and the drafting of proper contracts, and afterwards, clear communication and strong oversight, which also include an intense coordination among the principal and the contractors in the implementation of the safety measures. It's clear that failing to correctly manage all these aspects can lead to serious accidents in the workplace with very relevant legal consequences. Therefore, collaboration and vigilance are key to ensure the safety of all workers across the supply chain and to avoid any legal issues for all the employers involved. Looking forward, one final thought. Supply chain management is getting more and more linked with ESG requirements. Moreover, we don't forget about the CS3D directive, which basically extends the principal's obligation to assess the contractor's compliance with health and safety standards, also in cases in which the activity of the latter is performed outside the principal's premises or even abroad. All this is having today, and will likely have more in the future, an impact definitely on EU countries. But I believe it might also have some effect outside of the European Union. I would like to know what your opinion is on this aspect. Bruno, any views on that from your side?
Well, what I would say is that Brazilian authorities, they are paying more attention to the work conditions in the companies that provide services, outsourcing companies. And there is a trend of trying to make all companies involved in the supply chain liable for any cases where the outsourcing company fails to comply with basic rules of safety and health. In some cases, for example, when the contractor fails to give its employees the most basic health and safety elements, the labor authorities in Brazil, they may consider that these working conditions are analogous to that of a slave, of a modern slave. And these may cause not even the contractor, but also the contracting party legal and reputational, huge legal and reputational damages, right? So in such cases, for example, the labor authorities may try to make all the companies involved in the supply chain liable. So that means that, well, companies in Brazil, they do have to be very careful nowadays when contracting services providers to outsource any part of its activities, because depending on the circumstances and on the failure to comply with certain rules, these contractors, these contracting parties, they must be involved in very huge cases with very serious legal consequences.
Thank you very much. Thank you, Bruno. And Kenny, I mean, we are both European lawyers. I somehow expect what you will say, but please tell me if there's any particular comment from Belgium.
Thank you, Stefano. I will be brief because looking at the time, we do need to tackle some other topics. When looking at Belgium, of course, the health and safety obligations are essential elements of the social aspect in the ESG. And when we look at the CS3D, I think it mandates companies to assess and mitigate health and safety risk within their value chains. I think when we look at this new legislation, we think we can state that health and safety risks will now explicitly be part of a formal due diligence scope towards or of the subcontractors that we work with. I think companies must even more than already doing right now, they should conduct risk assessments that include subcontractors' activities. They should implement preventive measures and monitor compliance. They should include safety clauses in contracts and enforce them. They should also report on safety performance indicators and sustainability disclosures. And within Belgian legislation, this does not change that much, to be honest, because a lot of these obligations already exist within the Health and Safety Act. However, as I mentioned earlier, things go wrong a lot when we're working with third parties, and often parties forget their obligations mentioned in the Health and Safety Act. I hope and maybe the CS3D and the ESG legislation will make parties even be more respectful with health and safety implication. I think companies can lead by example through embedding health and safety in ESG governance. You can go to this next slide, Lesja. So they can embed health and safety in ESG governance. I honestly think it's necessary to integrate safety into board-level ESG strategy. It also could be important, necessary, and to support SMEs in the supply chain. Bigger companies could offer training templates, provide tools to help smaller suppliers to meet safety standards. Because very often we see that these smaller companies are not respecting all of their obligations because of they do not have enough budget, ignorance, etc. I think within the supply chain it will also be necessary to support SMEs within the supply chain. And last but not least, I think we should we are in digital times. We should use technology. We should use AIs. We should use digital platform to track incidents or to be compliant, to take corrective actions. And to provide these platforms not only towards our own workers, but maybe also to our partners within the supply chain.
Thank you, Kenny. Thank you very much. And Gabriela, does ESG have any impact on Mexico, refer to occupational health and safety regulations in the supply chain? And do you expect any kind of impact from the directive, from the European directive?
Yeah, well, I mean, ESG is becoming more relevant in the market right now. So most companies are trying to implement some regulations, internal policies that may help them comply with these ESG requirements. And also, I mean, even though the European Union regulations do not apply directly to Mexico, it is increasingly common that international organizations or international companies in Mexico, what they are trying to do is to create these global policies and of course health and safety policies that can be adapted to other jurisdictions. So what we usually see in Mexico is that these global health and safety policies are actually being translated or adapted to the Mexican framework to comply even though it is not mandatory to comply with best practices across the same organization. So it is really relevant. What I think it is important here for Mexican companies is, first, we obviously need to see which are the health and safety obligations that actually applies to us, depending on the industry that you are in. And of course, to ensure that we are complying on a regular basis with those health and safety and work environment regulations. Because as I just said, in the supply chain, even if there are some employees in our workplace that are not actually our employees, but are third parties employees, then there could be a joint liability for accidents or any safety breaches. So it is important that we ensure that proper training is being provided to employees. And of course, this is also to prevent any economic fines that may be imposed to employers during labor inspections by our labor ministry.
Thank you very much. Jose, I'm pretty sure that ESG has some impact on this topic in Spain, and I'm also pretty sure that you do expect some impact from the directive.
Of course. Well, the integration of health and safety obligations within the broader sustainability and ESG is becoming a key priority worldwide. And Spain is not an exception. Let me just introduce my opinion here. I think that there is a global pressure on this, and it is a movement, a step forward of all together being conscious about health and safety from an ESG perspective, and that is very good. And I think that no employer wants to be out of the game. They want to play. So reputation here is at stake. Then, well, Spanish companies are saying increasingly recognize that workplace health and safety is not just a legal compliance issue, but a vital element of social responsibility, the S in ESG. How is this reflected? I will say that in evolving corporate strategies or reporting frameworks, okay? From the transposition on Spain of non-financial reporting or the corporate sustainability directive that we know that requires company to disclose not only environmental, but also social and governance risk, okay? And that includes obviously the H&S in their operations and supply chains. Then an additional point is that well, occupational health and safety risks are explicitly included from a, let's say, human rights scope. Okay. Then with regard to non-EU suppliers, well, for Spanish companies, outsourcing from outside the EU means stricter due diligence and monitoring obligations, extending beyond their direct operations. Okay, they require them to push on established higher safety standards in their supply chains. The question here, Stefano, is how should companies, should Spanish companies integrate and lead? This, I would say, this at the beginning. We are just at the beginning of this process, but this is how I see it could be implemented. First, embedding, AHS and ESG strategies, which I mean, health and safety should be a core pillar of broader sustainability and ESG frameworks. Second, risk-based supply chain management. Companies should, must proactively map their supply chains, identify their high-risk areas of occupational hazards, and implement, obviously, tailor risk mitigation measures. Third, training programs for suppliers and contractors. Spanish companies can drive improvements by supporting training programs for suppliers and contractors, ensuring that these H&S practices meet this legal and also voluntary standard. And finally, there are two more elements: collaboration and with multi-stakeholder engagement. That means trade unions, industry associations, NGSOs, etc. So they share this knowledge and obviously improving collectively speaking safety standards. And finally, I think it's the similarity with Belgium. Technology and innovation. Technology should be used. We should use digital tools not as a way to, not be transparent, but as a way to try to implement this transparency and try to enforce compliance across complex supply chains. These bring to challenges and opportunities. Obviously, which is a challenge? Complexity, which is real, and then opacity. Opacity in terms of not being transparent with global supply chains, that is clear, especially in, I would say, international or multinational entities, companies. And then what is the cost for companies? Cost pressures with investments and safety improvements. On the other side of the balance, in terms of opportunity, I was referring to at the beginning, companies will enhance their reputation by embedding these practices in the ESG managerial way of doing things, reducing obviously accidents and associated costs, and this is pretty much what I had to say, Stefano.
Thank you.
Thank you
Thank you
very
very
much.
much, Jose.
Thank you to our panelists for the very interesting insights. We will now read one question that we received, and this is for Mexico, for you, Gabriela. Mexico recently reformed its labor laws on outsourcing, limiting to specialized services and establishing joint liability between contractors and hiring companies. What are the most significant challenges that companies face in adapting to this framework, and how can they mitigate the risk of being held jointly responsible for contractors' labor, tax, and social security obligation?
Thank you. So I think that the main challenge here is the coordination and the periodic verification that we've been discussing. So we should verify these health and safety obligations being complied with on a regular basis. And also, I think that most companies nowadays see this just as paperwork, but it is actually a preventive measure to avoid future legal risk and also economic fines that may be imposed by the labor ministry during a labor inspection. So additionally to doing this verification, this periodic verification, we should draft really clear contracts to set the obligations of each party and consistently monitor what happens with the employees that are actually at the workplace, even though they may not be our direct employees and they may be the third party's employees. But it is important that we have this constant verification so that we are in a safe spot with these other employees that are in the workplace.
Thank you very much. Thank you, Gabi.
Thank you.
Unfortunately, we are running out of time. But should you have a further question, you can reach out our panelists via email. We have a variety of resources and insights on the cross-border employment rules on our website, so don't forget to check them out. And for more information on our webinars, you can visit the events and webinar section to find all the past recordings and download the slide deck. I will also remind everyone that the recording and the slides for this webinar will be also on our website in the coming days. You can also take a listen to our podcast, Talking Work, in which we talk about the world of work. And finally, I would like to thank everyone for attending, and thank you to our panelists for their very interesting insights today. The webinar will be now ending. Thank you very much, and have a great rest of the day.
Thank
Thank you
you.
very much.
Thank you.
Thank you.